Namaskar and welcome to the Citizen Justice Forum podcast. I am Advocate Sulaiman Bhimani, founder of the lawsuits and president of Citizen Justice Forum. The objective of the Citizen Justice Forum is to empower citizens of India by creating awareness about their fundamental constitutional and legal and property rights. Today's topic is extremely important, especially in cities like Mumbai, where every second building is going for redevelopment. This is an unprecedented speed. It almost feels like every second building in my neighborhood is going for a redevelopment. However, many housing societies and flat purchasers are still unaware that one very crucial aspect is conveyance. Should a society go for deemed conveyance, or can societies obtain conveyance through consumer court? What are the differences between conveyance? What are the advantages and legal implications of both the remedies? To guide us on this very important issue, we are honored to have with us an experienced and legal expert, Advocate Uday Wavikar.
Okay, Namaskar.
Advocate Uday Wavikar is highly respected in legal profession with a vast experience in consumer law, cooperative housing societies matters, and redevelopment issues. Conveyancing and real estate litigation. He is currently serving as the president of Consumer Courts Advocate Association of Maharashtra and Goa, and has made significant contributions in the field of consumer justice and housing society litigation. Through his extensive legal practice and guidance, he has represented and assisted numerous housing societies and flat purchasers in protecting their legal and property rights, especially in matters relating to redevelopment and conveyance. He is also founder of Uday B. Wavikar and Associates, a legal law firm reputed in Mumbai based on law practice known for its work in consumer disputes, redevelopment issues, RERA matters, and real estate legal advisory. Sir, it is truly a pleasure and honor to have you with us today.
I'm also pleased to be with the Citizen Justice Forum.
Sir, considering your vast experience in consumer litigation and redevelopment disputes, today's discussion will surely help thousands of housing societies and home buyers to understand their rights in this rapidly changing redevelopment landscape. Before we begin the discussion, we would request Advocate Uday Wavikar, sir, to briefly explain to our viewers what exactly conveyance means and why it is so important for every member and the society to have the conveyance.
Conveyance, people think in a common parlance, conveyance is a kind of vehicle allowance, which is not so. The burning issue in properties is conveyance means transfer of property from the landlord to the home buyers. Now, what has happened is our country, there are very beautiful ways of avoiding the payments to the government revenue. So, therefore, the lobby of the builders came with an excellent idea, especially in metropolitan cities where the properties prices are more than gold and diamond, and they have gone much more than share market. So, therefore, every inch in Mumbai is really costly. Sometimes I have heard the lawyers telling their assistants that please see that you give justice to your chair, which is about 50,000 rupees per square feet. So the point is the transfer of the property is very important in the name of this housing society, in the name of flat buyers. The new scheme has come of ownership of flat buyers that we will take a separate issue. Today the main thing is, like, let me quote an incident which happened when I, Ramesh Prabhu and Mr. Vijay Samant had gone to a building known as Lakshmi Chaya. Most of the jewelers are staying, and this building is situated next to the Bhagwati Hospital in Borivali. And we, as usual, gave them, it was about in about 10 years back, and we gave them the entire idea of the conveyance and how conveyance can be done and why it is important. I said the building that is standing on the land does not belong to the society. If something happens to your building, then how are you going to build? Because the landlord may ask for the market price at that time because you have not got the title transferred in your name. This is a burning issue. But let me tell you, there is something called deemed conveyance coming. What will be the expenses and the consumer forum to go? At that time, it was, we said, hardly 3-4 lakhs. The entire proceeding, legal fees, and everything will take. They said, sir, why should that? The deemed conveyance would come free to us. Now, how free it is, everybody knows. But the point is that they were hoping. Suddenly, what happened? Khuda na khasta, the whole building of Lakshmi Chaya collapsed with an accident, and then they had to do the convey. They had to do the building again, rebuild. The builder agreed for a concession rate. All the politicians involved, including Sir Gopal Shetty, he also did a lot of efforts. The local representative and member of parliament, but and the builder agreed at a very reasonable rate to construct the building. The landlord said, "No, I will ask the market value now." And there was a difficulty. They had to pay through their nose 1.5 crores, 105 crores, which could have been hardly in 3-4 lakhs. And this was told by the secretary of that building when I did a presentation in IC Colony. And he explained, I did not remember. Then he told me that he was the then secretary of Lakshmi Chaya. Similar thing can happen to anybody in Bombay. And conveyance getting property transferred on your name is very, very important for redevelopment, because the title, if is not clear, no builder would put his hand to do the conveyance, or if he does the conveyance, then he'll reduce the size of the flat for you. So therefore it is, and that is also very difficult, because now the deemed conveyance has come. We will come to the issue of deemed conveyance later, because there is only certain places where the deemed conveyance is appropriate. Otherwise, Justice Kochar called it a doomed conveyance, and we will come to it as to why. Because it is said that a shortcut is always dangerous. Consumer Act now as is very progressive, and looking at the difficulties of the consumers, the especially Supreme Court, especially Justice Gowda gave a very good judgment, which actually I am going to circulate and you can have it. This judgment is so vital and point, called Kamlesh Agarwal versus Martin Singh Dabbas and another. Justice Gopala Gowda has passed, saying that para 18 is very important of this judgment, and saying that in case the landlord is not available or the builder is not available to sign the conveyance deed, because consumer court is to pass an order straight away that all the parties are directed to the conveyance. Now, if there are certain ex parties where we have done the service by publication, how they will come and sign? Therefore, then this order, which is they said that under civil code, the order 21, rule 32 and 34 are very vital, where a registrar can sign in place of defaulting party. And this was the landmark judgment in para 18. I will not keep reading the judgment. You can refer. We are producing
Yeah.
this judgment.
So, for all the viewers, if you want this judgment, we will give a link in the description of the YouTube description where you can click and download the judgment, and you can read also and use it for your own benefit.
Now, what is happening is, once a society gets the order of conveyance, and in case the parties do not come, sometimes landlord says, I want my money from builder, more money. He becomes greedy because the rates have gone sky high. Then it is very difficult if it doesn't come to execute the conveyance deed, if the parties does not come before the registrar. So therefore now, the under this judgment which I just quoted, Kamlesh Agarwal, now the registrars have been empowered of Bombay Consumer Courts to sign on behalf of defaulting party not coming and not cooperating. Therefore, whether the builder comes or not, whether the landlord comes or not, we will get our conveyance degree executed. Another beauty is, my experience, cooperation is different, and in consumer court registrars are a bit straight. So now point is, they are very efficient also, and the best part of is, registrar doesn't have to come before the registrar.
Okay.
Once he signs, he doesn't have to appear before the stamp duty registrar or the respective mutation entries registrar to transfer this conveyance. That is the ease of the entire matter.
So, it is better to obtain conveyance through consumer court rather than going
Sir,
in a shortcut way.
that would be a very explosive and debatable question. But I will tell you where it is good to go for deemed conveyance and where it is not good for going Overall, consumer courts are treat to buy. I have sent 7 builders to 3 years rigorous imprisonment under the Consumer Protection Act, Section 72 now. That time it was Section 27
27.
for 3 years rigorous imprisonment. And the latest is Ami Builder. Judgments are available. I'll give it to you.
Yeah. So
He went to the jail and now he's ready to do everything. So settlement has been done. So, but that provision is not under deemed conveyance. Where it is good to do deemed conveyance is a question. The question is, you can do deemed conveyance. Like I did a conveyance for 70 chawls in Andheri. I will not tell you the builder because it's got very big land without any amount to be paid. How it was done? It was done through the magic of deemed conveyance. We registered the entire chawls under a society, not even the federation or society, and every chal was a member, and the members of the chals were member, because in chal you don't know one Christian, one Muslim, one Hindu, and where the owners were years together, nobody knew. So we filed a deemed conveyance. Deemed conveyance are granted, registrar signed, nobody to challenge. The conveyance took place. But where a builder is now going to contest because the rates in Bombay are skyrocketing, and he is going to get FSI and TDR free, he is going to get the land free, which builder will not contest? That is one of the reasons that builders are not doing the conveyance. Either they'll get a partner or they themselves would like to redevelop the building. Because by then so many years have passed. Once a redevelopment is done, your 7th floor building will become 38 floors, 40 floors. And where is the place in Bombay? Only going up. Up means
yeah,
skyrocketing up.
not to the other one.
There is otherwise there is no place in Bombay. Okay.
So now we come with a question. Sir, for the understanding of the common citizen, could you kindly explain in simple words what is the difference between conveyance and deemed conveyance, or conveyance obtained through consumer court?
See, when you go for a deemed conveyance, हिंदी में उसका ट्रांसलेशन होता है समझ लो कन्वेंस हो गया. मैंने तो नहीं सुना है समझ लो शादी हो गया. But the point is, here what happens is a convenient thing because registrars have been now empowered as a competent authority. Now there's a basic debate which I would just mention. Common man may have little difficulty, but it is simple. That a judicial function cannot be taken over by administrative function. And this happened in Competition Commission. When they appointed an IS officer as a head of the Competition Commission, protests came from various factors, and then a retired justice of Supreme Court has been made president of Competition Commission. Here what has happened is the entire powers are given to the cooperative registrars, and then there are shortcut conveyance, there are 1 month conveyance. Now they are saying 1 day conveyance, and now they are saying directly flat will be conveyed. There is no espresso coffee. The rights and liabilities, especially the rights, because the flat owners are beneficiaries. Therefore, they should get a conveyance which is free, absolutely free of any encumbrances and problem. Nahi to, as Manmohan Singh once rightly said, the Manmohan Singh ji, our Prime Minister, that time used to really give beautiful speeches. He said that खता लमोने की है, सजा सदियों ने पाई है. If you do a wrong conveyance, the आने वाली पीढ़ी आपको कोसती रहेगी when it goes for redevelopment. So your conveyance has to be rightfully done, exactly done, proper measurements are to be there. It should not happen now with what happens with our experience of deemed conveyance. Registrar doesn't know so much technicalities. So whatever the society says, he would pass an order of deemed conveyance. On what I am not saying, but he would definitely fast to give the justice fast and quick. And therefore, then the High Court will find out that there are problems in the conveyance by the size of the plot, by the exact, and then sometimes one society's land is given to the other societies when there are many societies on the plot, and then the stay would happen. People are under impression that on the deemed conveyance there is no stay, there is no question of any stay or appeal. No, there are several writ petitions where the deemed conveyance are stayed. And of course, after spending the money before the cooperative registrar and following the procedure for well known to you, suddenly when you go to the High Court and you get stay on your deemed conveyance, then how many years you will fight a litigation, God alone knows. And then number of years you are let out for that kind of conveyance. And if the order comes that conveyance is not proper, again you have to go through that procedure. Therefore, in a consumer court, we advise our clients that get a proper land demarcated and marked by an architect. calculations of TDR and FSI should be correct. If possible, when you file a consumer complaint, only you file along with the complaint the conveyance draft, because otherwise court has no option but to pass an order that the conveyance should be given to the society. How much, how big, how small, not calculated. And then in an execution, the builders plays the role saying that this is order is not correct, this society doesn't belong, this was small place only available, parking not available. So these are the problems.
Now, in today's redevelopment scenario, why is obtaining conveyance becoming so important for the housing societies before entering into a redevelopment agreement?
First of all, the builders, the rule is very clear. Unless the property is on your name, how can you transfer a property for redevelopment? You can't do redevelopment without conveyance. Conveyance is a must for redevelopment. Now, if the conveyance is not done, now does the builder undertake the responsibilities to do the conveyance? There are times when builders have done expenses of conveyance, got the conveyance done, or got the other builder also together to do the conveyance, or the landlords together to do the conveyance, because at that time the landlords also can raise a demand,
Yes.
saying that I also want a flat, I also want this. So therefore, but the process is very difficult. It's your right. You have purchased, you are on ownership, you are not on rent. So therefore, every flat, now that scheme is coming, every flat would belong to you.
Yeah.
But that is still far off.
Far
So
off.
today,
And still
today,
there are
today,
the nitty-gritty
lot
has to
of
be worked out,
complications
yes,
are there. We'll come to
complications.
that. That's a different issue. But today, the conveyance to rebuild the building in the name of society as direct ownership is very important. And High Court to this extent, in Ratnarupal, I remember Justice Roshan Dalvi has passed a very outstanding or daring judgment, and which is still there. It says that once the society is registered under MOFA Rule 9 and the Section 11, within 4 months of registration, the builder shall do the conveyance. Now, if it doesn't do the conveyance, what happens? Ratnarupal's judgment says very clearly that even if there is a right of builder to build a sea wing in that land, he seizes that right and the entire TDR and FSI goes to the society.
It goes to the society.
So therefore, society becomes the real and fiduciary owner. But practically it does not happen. Unless the conveyance is done, registered, demarcated, stamp duty is paid, then the mutation entries are made and society's name comes on the property card.
So
That is
that's
what
why
is
when
conveyance.
we make a redevelopment agreement,
Yes.
we say to the builder that all the permissions or the
Are
TDR
given.
has to be taken on the society's name.
Correct.
But if the plot is not in the society's name, that is not possible.
Absolutely different.
Now I'll give you a current and live example of my this thing. I have 2 flats in Mount Mary Road in Bandra, which is supposed to be a very high end, very expensive area and very. So 2 different society have a 2 different approach. In my society, for the last 12 years, 15 years, you can say, the deemed conveyance application was there, it was pending. But after taking me as a chairman, and we were able to pay and get the order, paying stamp duty of 29 lakh rupees. And it's very soon we are going to sign the deed of assignment. But the other society is going for a redevelopment, right? The plot is not in the name of the society. They are saying builder aega, builder karega. So I am confused, and many societies are also confused like me. So they are waiting that we'll sign the redevelopment agreement and the builder will come and do the deemed conveyance or the conveyance for them. So how far this is true? So now whether means they have 3 options. Wait for the builder to do the conveyance. Second option, they go for the deemed competent authority, or third option is they file a complaint in the consumer court. In the other society, I myself as a single member, I have filed a consumer court against the builder and I have made party the society also because they failed to do their duty.
Correct.
Right? So last 45 years, they have not done that anything about the conveyance. So in this scenario, what is your advice?
Well, it's really, I would say it's a very, very pertaining and latest situation question, because this is the biggest issue today. The point is, builder tells the society, I will do the conveyance, you don't worry, and grabs the contract of redevelopment. Then the real picture starts coming. Thereafter, the real movie starts. And then the builder says, no, it will take time. Then he will. There are three categories of builders who say, one says it will be so many expenses. There will be 60 crores, 70 crores, whatever amount for conveyance. So society should contribute. Or what I will do is I will do the expenses of the conveyance. I'll get the land conveyed. I will get the land transferred. But ultimately, what would happen is I would reduce your size of the flat.
Yes.
Or certain flats will be taken by me.
Yeah.
So how much, instead of paying hardly about 20, 30 lakhs for conveyance, or maybe less than that, apart from your stamp duty, you are ending up paying in 5 flats, which are about 5 crores and 6 crores to builder. And after that also, if it doesn't do conveyance, that what happens? I'll give you an example of New Ambuli Society in Veera Desai Road, which is now developed by Chindak Builders, but that time it was taken by Sri Borkar and it is recorded. We filed the case. And what had happened was he promised him to get a conveyance done through the collector. It was a collector land. So it has to be done freehold. That time it was not that 10%, 15% was not there. Now it is 10%. I have also got my land freehold.
Yeah.
That you can get. But that time it was not so. So expenses were more and he could not do. So he had put a deposit of 50 lakhs advance as a guarantee money. And it was the only society who, with our assistance, Mr. Hari Shetty and all other solicitor barrister, my partner, we did an effort there, and then the entire agreement of redevelopment was cancelled with Mr. Borkar, and those 50 lakhs, with lot of efforts filing the suits, were encashed by society without leaving the flat. But this happens very rarely, and therefore the point is, don't leave it to the builder. It is like the story of chidiyas who making khoslas in an farmland, and where they said tomorrow the friends of the farmer are coming and cutting. She said, you don't worry, relax, nothing happens for the 15 days. Then he says, relatives are coming, nothing happened for the 15 days. When the farmer says, I will myself cut, then only it happens and chidiya ud jati hai. So the point is, you have to, the society has to exercise this right. It is their right, and they should be aware, because unless the conveyance is done, you should not become Lakshmi Chaya or the other central building. Otherwise, we will face a lot of difficulties.
Now, there is one more question which comes into the mind. Suppose if the order is passed, the builder is alive. Is there any criminal provision where the builder can be put behind the bars if they don't comply with the order of the...
Of course, we have said now, I am giving you the Ami Builders example. The Ami Builder about 10 years back did not do the conveyance, did not get the OC. It is at Borivali ALC colony. We underwent through the consumer court execution proceeding. And in the execution proceeding, he was now sent behind the bars for 3 years. Now he has come for settlement and everything is taking place. He said, I can't do the OC, but now he is doing the conveyance. And conveyance we will get it done through the registrar of consumer courts, because the order is already there. Remember one thing, in a consumer court, you have to first obtain an order for conveyance. Then only you can go for this registrar's unilateral criminal proceeding as well as unilateral conveyance. Unilateral conveyance is a big thing in consumer, because suppose the landlord doesn't come. I'll give you an example of bliss and blessing. Like we have done 7 societies, more than 7, 8 societies with this unilateral conveyance. We also have done Rukmini Nivas, so many societies, and I have given those orders. So in that bliss and blessing, which is at the Dominic Colony, Orlem, on this side is Shankar Lane, that society, the builder was ready to transfer. Chandrakant Gosalaji was a builder. He was ready to transfer, but the landlord was not ready to come and sign for obvious reasons of extra money. Then we went for unilateral conveyance. It was one of the first cases of Bombay Consumer Forum, Mumbai District Suburban Forum, where the honorable judge came forward and Rathod ji, he said, we will pass the order on the basis of Agarwal judgment. And the first time that judgment was passed, that in place of the landlord who was not cooperating and not coming for signing, in spite of several warrants and all that, he was abroad, the registrar were empowered to sign, and registrar signed, and that conveyance is taken place.
What are the advantages and limitation of obtaining deemed conveyance through competent authority?
There are advantages, as I said, if the matter is not going to be contested, then deemed conveyance is much faster, and it can be easier in terms of, though there will be like a lot of expenses, one has to know what would be the exact expenses, including all the expenses. And when I say all, the word all is underlined. So therefore, then I think deemed conveyance would be good, because once it is pretty fast, registrar gives the order, nobody is going to contest, वो शादी हो जाएगा क्योंकि कोई opposition ही नहीं है और आप आराम से रह सकते हैं. मगर where it is contested, and most of the time it is now contested, because conveyance is very very important for builders. Otherwise they can have the advantage of crores of rupees with the new guidelines of redevelopment, where a 7th floor is building can become 34 or 65 in Mumbai. 1:4 of a clustered redevelopment, there is 1:7 FSI given, then it is lucrative. And now it is said that this kind of carrot will be also given to suburban. Now it is 2.5, sometimes with tidbits it goes to 4. But now like Mumbai city, suburban may get 1:7. We already have skyscrapers till Andheri, and there will be further more 100-floor buildings. So therefore, because cost of the land is going really high. So kal kare so aaj kare so ab. The advantage of deemed conveyance, where there will not be contested, builder not available, nobody will contest, you can do deemed conveyance. My advice. But otherwise, if you are contested and it goes to the High Court, and by chance it gets a stay in High Court and then thereafter Supreme Court, maybe your next generation will get the conveyance. In the Consumer Court, penal provisions are there. Builders are scared of penal provisions. Secondly, many builders have been sent to jail. So therefore, your conveyance can be done fast and accurate, and it's a civil decree. समझ लो कन्वेंस हो गया, ऐसा नहीं है, डीम कन्वेंस नहीं है. It is a decree where it says a clean conveyance of the title is transferred to you by civil court who is empowered to give the conveyance. So therefore, I have told you there's an issue between the executive, whether executives like registrar, though they are competent authorities, can be made in charge of judicial function, and that dispute will not come at all. It takes time in consumer court because infrastructure is not there. But once the orders are passed, there are penal provisions. There are also provisions of fine per day 5,000 rupees not doing for conveyance, and then societies are benefited. And therefore, you say the patience, Saddha or Saburi, your faith and patience can pay you off well in consumer court. And now the new provisions of unilateral conveyance has done it faster and smoother. So preferably, not because I am in consumer court, if your matter is contested, please come for consumer court, because the consumer court is generally for consumers, and therefore the justice is on equitable basis rather than technicalities of the law.
So you believe consumer courts sometimes provide stronger reliefs compared to deemed conveyance proceeding, especially where builders have committed deficiency in service and unfair trade practices.
And especially when they would contest and not give the conveyance easily. That is very important. So there the orders of the consumers have penal provisions, and those penal provisions are 3 years imprisonment also.
In many redevelopment projects, societies realize at a very late stage that the land title or conveyance is incomplete. What risk can arise if redevelopment is initiated without proper conveyance?
Nobody will do the redevelopment without conveyance, because the people who are there, landlords, will definitely go to the court, or even the builders who have constructed the previous building, if you appoint a new builder, can also go in the court and get a stay, because without land being in the name of society, begani shadi Abdullah Diwana, aisa ho jayega. That is not possible. People are under misunderstood impression that builder would go and spend. There is no free breakfast in this world. Builder would spend for you. Builder might be able to get a conveyance for you, but at the cost of certain number of flats and your size of the flat in the building, you think over what that would cost you.
So it's a very good piece of advice for the
Yes,
managing
yes.
committee members who
Yes.
are, pushing redevelopment.
Oh, please, sir.
Builder will
Managing
do the
some of the
conveyance.
see what has happened is in this redevelopment. I would not blame any, because human beings are human beings. There are committees which are only formed for redevelopment, and those committees are more popular and more there is more demand. They would not become the chairman of the society, but they would like to become redevelopment committee member. There are certain, they think they might get ACs free, they might get additional parking, and of course further so it is a very lucrative post, like political post. So therefore, don't create a committee which will become against the original management of society. Let the original management manage, and there are now self redevelopment also concepts where you can appoint a builder and society can run, but the faith and trust has to be there. Because olden times, like-minded people used to come together, plots were allotted by government to them, those societies, and they used to redevelop. And that was smooth because the economic stanza, the understanding, like-minded religious beliefs, all that was together. Otherwise, further in the building where it is resale for 25 floors and about 35 floors, all different religions coming together, and then there can be complication of cluster class and all that. That's a different complication. So therefore, see that if there's a faith of the person, then even the option of self-redevelopment is good, provided there's a faith and provided you have finances to organize to get the redevelopment.
Sir, what are the most common mistakes committed by societies and managing committee during redevelopment negotiations with the builders
See,
and the developers?
very good question, sir. What has happened is there are a lot of dream sellers in the market. जहां आपको आपका 1 bedroom फ्लैट है, at the most you can get 2 bedroom with the smaller bedrooms and additional FSIs and TDR loaded. There are people selling the dreams of 3 bedroom. There are people selling the dreams of swimming pool. There are people who are selling the dreams of various amenities like clubhouse, etc., and AC lobbies and then greenhouse. But actually, it is not possible. And with the dream, some builder has been sold to your, been committed to give these dreams to you. He does an the development agreement, and then he can't fulfill anything, and then the same builder sells with your power of attorney irrevocable, sells it to the third builder. Like look at Vaidehi, Akash and Rustumji. Cases are going, we are contesting. I am successful to get all the three as involved, especially the society is also liable, Rustumji is also liable, and the Vaidehi Akash is also liable. Now that matter is contested in National Commission by Rustumji. So that the what happens, the Rustumji says, I have no priority of contract with the people who have bought with the first builder. So, but that is not so. He is doing it. Promoter definition under MOFA says the person who wants to construct, that is the landlord. Person to whom contract of construction is given, that is the builder. His assignees, like Rustumji is an assignee here. His assignees A, B, C, D builder. There will also be promoter, and the brokers, if they are not the same person, will be promoter developer. Such a wide definition of consumer. And Goregaon Pearl, this is another judgment where the deemed conveyance could not do anything. People have their rights on the flat, but at the same time, when in Goregaon Pearl, consumer courts have passed good judgments for them, they will at least now get the refunds. Of course, the flat will not be, they may not get the flat, but refunds can be given to them. Consumer courts have come to their assistance.
And that refund has to be given by the society, not by the
and
developer.
correct. That is the most important file. The society has been made liable to give the price of the flats and not the builder or give the flats. So
No.
that is, society is also more responsible. So let society managing committee be aware that it is not only cream to be eaten of the redevelopment, they are also liable and responsible.
Can an individual flat purchaser also seek remedies independently if the society or managing committee fails to take proper action regarding conveyance?
The first object of bylaws of the society is to get the conveyance. And if the managing committee does not do that for various reasons which we all know, then in that case, any member of the society can contest. Even in consumer court, such a dispute between society and member would come in because they have not done their diligent duties. It would amount to unfair trade practices and deficiency of service. Because ultimately, beneficiary of services is the member of the society. And therefore, dispute between member and society of this aspect of non-compliance of the objectives of the bylaws, which is number 1 bylaw of conveyance, is absolutely valid. There are several judgments in consumer court, and especially the judgment of redevelopment. There is a redevelopment judgment of Kirchan Gulati, which is very famous. That the Supreme Court said even if a landlord gets 10 flats for his relatives and 5 flats to buy, 5 flats to sell in the market, not buy, sell in the market, make profits, he is still a consumer. So therefore, the society as a going for redevelopment will be a consumer if the conveyance is not taken by the society, which is their obligation, statutory obligation from the builder, does not file a case, then that member can file a case in the interest of all other members, directing the society to get the conveyance from the builder and also make builders equally the party, all the promoters equally a party, and such cases are upheld, orders are given, and even penalties are put like Goregaon Pearl. Penalties are put on the society for getting a proper conveyance for the purpose of the members.
In your opinion, what precautions should every society take before signing a redevelopment agreement?
It's a very, very, I would say, put the oil in the eyes of the lawyers, and the lawyers will have to check the entire agreement, because redevelopment agreement is nothing but a Bhagavad Gita for you for ages to come, for sadiyos to come, and they will be responsible for your mistakes. As I said, कि कथा लमो ने कहती सजा सदियों ने पाई थी, ऐसा नहीं होना चाहिए. Therefore, a proper conveyance from a proper solicitor with the proper title deed, a proper search will have to be done, because unless you have a proper title to be transferred, then how the rights will be created, there will be complications. Again, the builder can say in there, because most of the redevelopment agreements are one sided because they are not properly checked. The builder will say that the parking will belong to me, the terrace will belong to me, the balconies would belong to me, and additional area and TDR and FSI if any will also belong to me, would be absolutely incorrect, unfair agreement, and such clauses of agreements are not executable because they are absolutely unfair. Under the we call, there's a special law that the might dominating person cannot exploit a person's advantage, that is mere litigant or a buyer, home buyer cannot be exploited, and there is a DLF judgment where 300 crores were charged for one-sided agreement to the builder, and that was then reduced by the Supreme Court. It was a competition commission judgment. So these clauses in the agreements are not enforceable, but you must see that these clauses are not there. Otherwise, you will be also partially, chances are involved that why did you agree to such clauses when you are aware? Ignorance of law cannot be excused also many times. So you have to get a proper conveyance deed drafted by solicitor who is expert. Like in case of more than 3 blocks in heart surgery, with my limited knowledge, you have to get it done from heart surgeon and not an cardiologist, unless the sins are put. But more than most sins are more, sometimes if you have to do a heart operation, then a surgeon is required. Therefore, a solicitor is required than lawyer to draft a conveyance deeds according to me. And they, especially whether the lawyer or a solicitor, thorough search has to be done. Thorough findings have to be done of correct FSI and TDR, transferable, and which would be in future transferable to you, and your benefits have to be secured. Otherwise, you can be in big problem. Because most of the conveyance deeds today, you will be surprised, are done as lease deeds. You have bought it on ownership, but biggest builders of Bombay for the township and villas outside the Bombay, or even weekend houses or in Bombay, today are saying that we will give you a lease deed. There are many societies like Shere Punjab. I am giving an example because it is my case. Shere Punjab said we will give a lease deed to a builder. Builder constructs the building after 20 years. When conveyance comes, builder says I only have a right of lease deed. आप भाड़ूत बन जाएंगे ओनरशिप पे लेने के बाद. So the point is, then the Shere Punjab, we had made a parties to Shere Punjab, and Shere Punjab also was required, like Goregaon Pearl, to give the conveyance, and if not, then the penal proceedings would go under consumer court, and they have not done to many societies. The after filing a case in consumer court, conveyance has been done or ordered for the societies.
Now, sir, considering the present redevelopment boom across Mumbai and Maharashtra, do you believe the law relating to conveyance and redevelopment should be updated or enhanced for protecting the interest of the society and the existing member and the new home buyers?
I think we'll have to do a lot, because that individual conveyance idea is there. It is difficult, but it can be done. Secondly, what is happening is the conveyance right, the lease deed is done, or especially there is a new arrangement under Apartment Ownership Act called condominium, which is Shobha Hibiscus and others. In a condominium, it is very difficult to get the conveyance through the courts. It is better to form a limited society and get a conveyance deed, because under the condominium, right away declaration, deed of declaration is done first only. What I am making simply is, deed of declaration when you do, the builder gives a conveyance, but that conveyance is according to him. So it is always better to get a society proper conveyance deed done, formed, because society is a limited company, and therefore it is a person under the act, and there is a big issue in consumer court also, whether society is a person or not, but the act has defined it as a person, and act has defined as the members of the society as beneficiary. Therefore, society today is a consumer. There is no judgment against the saying that so the societies are not conveyanced today. The judgments which are now stayed in the Supreme Court are also stayed, and there is no order of setting aside saying that society is a consumer. So therefore, the society formation and conveyance would be much better. than rather than having a condominium. Condominium, then every flat is transferred and there can be complications. Like the builder can keep the advertising place on the terrace, builder can get the TDR and FSIs. So it is more today acceptable mean, but more improvisation has to be done where a conveyance at the like in outside cities it is very simple. Bombay is complicated because the values of the land is like more than gold and gold and diamonds. So therefore, like Campacola case. So therefore, what is important is that the transfer of title should be immediately done by sale deed. Like you buy a bungalow outside, they will do the sale deed immediately. So conveyance is done immediately. But why? Here the occupation certificate is given part by part. 2 floor occupation, 4 floor occupation, 5 floor occupation, and that is why Campacola arises. So that is why the complications of conveyance become more complicated because of the demand. So therefore, had the demand not been there, builder would have immediately transferred. But today it is not so. So therefore, there we'll have to invent like a new procedure only that like before OC, you are not allowed to take the possession. So simultaneously, builder should also do the conveyance prior to giving possession of the flats to the flat buyer. How that dream has to be achieved, what system law experts like you and me and others can sit down and work out. But that is required mandatorily today, is the burning demand by all the buildings in Mumbai or all such metropolitan cities where you can really have peaceful title and sleep happily.
Sir, after such an insightful legal discussion, we would also like our viewers to know more about the person behind this legal expertise. How does Advocate Uday Wavikar usually begin his day, and how do you balance court practice and client matters and personal life?
I think this is a very difficult question to answer. And please don't allow my wife to see it. Perhaps she would be saying, "You see, the point is, she is very happy about it. But the point is, person, when we are devoted to a cause like doctors and lawyers, we are 24 by 7 on duty. We cannot differentiate. And according, for me, it is a passion. When it becomes a passion, I am basically a MBA from Bajaj. I was with TCS. I had the high rank in TCS, and thereafter I was also vice president of American Express Bank Capital Market Operations. Such a lucrative job. I took a voluntary retirement and came into legal practice in 1994. Today, 31 years, and I went to the consumer court. At that time, the consumer court was only for TV, freeze, etc., etc. There was no question of such a big question of land, titles, builders, crores of rupees, marine insurance, which is there now before the consumer court, or the plans and seeds cases also. So consumer court today have 95 acts under it. Unfortunately, it is under food and civil supplies. We will want to be this to be under law and judiciary for better functioning of consumer court. In fact, I feel in Bombay there are only 4 consumer courts. But you again, as we need nearly every court for every suburban by population. Delhi there are 13 consumer courts, whereas the whole of the Mumbai having 3 crores population, central and western suburbs have only 4 courts. So that is what is required. But as far as the personal life is there, there's a happiness when you achieve the something in profession, and when you are devoted to your profession as a passion, you can enjoy. I also simultaneously see my TV. I take out my backlog of the this thing I rest, and during the flights I also see movies. It's not that I don't see, but at the same time, to get something in profession, you have to sacrifice something, and I'll admit that. You have to be devoted. You have to be, main thing is you have to be very clear to your customers, because your reputation not is built over the years. It can get spoiled in minutes. My colleague advocates, I would explain that don't go for only money. Also look after the satisfaction of your clients, and that is the ultimate rewards, because their blessings would help you.
That's fine. Now, what inspired you to enter the legal profession?
I would say illegal profession is still like a drama actor. We are every day online on a stage and performing online. Performance in the court is really, it's like becoming an actor and acting in a drama online, which is their life. It's not like a recorded movie.
Yeah.
Therefore, the challenges in this profession are too many. And once you understand that the complications, and when you get real fun in studying and real fun in presenting the matters, and real fun in getting the satisfying results to a real consumers or the buyers or for the clients of yours, and then their appreciation is the utmost reward in this profession.
So I would say that as an advocate, we are performing live
Yes.
every day in front of the
We are a stage performer,
stage performer.
and all kinds of judges are there.
And there is no chance of retake.
Yes.
Like in the movie, there
No
are
chance.
10 retakes,
No.
100 retakes.
There's no retake.
Here, there is no retake.
Bas. Your words are like weapons. Once that missile is left, you can't call back.
Then which area of property and society law do you feel citizens are least aware about?
I will always say conveyance is one of the biggest issue which you have taken. See, people, richest people in Bombay are buying a second house in a township, where the township they are purchasing it on ownership. But what has become is the biggest builders of Bombay also are giving lease deed, which is not correct. You cannot transfer a defective title than what you have. Why are you doing that? And we must bring the awareness. We lawyers, like you are doing, and I must congratulate you. Citizen Justice Forum is doing this, but most of there have to be more forums to bring about the real truth of what you are buying. And people have no time. They just sign the agreement. Builder says this is fantastic. Amenities are fantastic. Everything fantastic. 30 years lease. After that, I'll revise the lease, and then you enjoy. You are in a real soup. So therefore, it is required that यू ऑलवेज कंसल्ट अ लॉयर. एक सादा फ्रीज आपने खरीद लिया, 2 दिन में दिया नहीं तो आपकी मिसेस घर में नहीं आने देगी, आप वहां जाके बैठ जाओगे उसकी दुकान में. बट crores of rupees flats you are buying, builders are not delivering it for years together, you are not taking a single action against them.
Not even writing a single email. I have come across
Yes,
so many clients.
but that is afterwards. I am telling you, even before entering an agreement, do a due diligence of builder. Go to a lawyer, get your agreements verified from a lawyer. You don't take. You only look at what builder have. He has a Mercedes. He's got lovely office. This, that. He will fulfill. No, it's not so. And then you get really trapped. Your hard-earned money you put in a flat, which is your dream for the life, and then entire Sahara for after the retirement, and then you don't get it for years together. It's really frustrating. So therefore, a stitch now is better than stitching nine. So therefore, before you enter an agreement, please consult a lawyer. Lawyers are not that costly. Then what you will have to face tomorrow.
Yeah, means they are ready to part crores of rupees.
Correct.
Rather than paying 10,000-15,000 rupees to advocate to
Advocate
get their
to get the
agreements.
agreement. That is the problem. Doctors will rush for every small thing. आपको सर्दी भी हो गया तो आप immediately जाके check कर लोगे. But here, when you are buying crores of rupees property, what due diligence you are doing? Ask a question to yourself.
So I will put it in a one line. They are penny wise and pound foolish.
I won't blame them, but because the builders are so beautiful marketeers and dream sellers that they get caught and they think he's a big builder and there's nothing big or small. You have to check the financial situation of builder.
They get hypnotized and mesmerized by the presentation of the
Therefore,
builder.
you have to do proper due diligence with his background. Look at his financial condition. If necessarily, look at his balance sheets. Do the proper analysis. Now, RERA may you get the records also of litigation also. So after checking properly my advice is buy a ready position. Don't go for booking while development. Very difficult to. What complication can occur, you cannot say. ये हाथ से चाबी लो, सोसाइटी रजिस्टर्ड है, ओसी है, पानी है, इलेक्ट्रिसिटी है, कन्वेंस नहीं भी किया हो तो हम कर देंगे आपके लिए. बट द पॉइंट इज एटलीस्ट दिस मेनी मिनिमम थिंग्स यू सी before you buy crores of rupees properties, and you may have to buy a building where a flat is after 10 years, but that will be more streamlined plan and worth it.
So the last question before we start the rapid fire. What advice would you give to the managing committee members and young advocates dealing with redevelopment matters?
It is, I would say, a precaution is very, very important than going for QR. If you take preventive steps like watertight agreements, preventive steps like search of the land, preventive steps like title of the land, preventive steps like whether there are any dues on the land, boja kuch hai kya, stamp duty is pending to be paid by builder or not, all these municipal taxes paid or not, all this study has to be done, and thereafter the reputation of a builder also has to be seen. And that reputation means I don't say where he has the offices, etc. His financial position in terms of project, whether he can afford, what are his past performances, and then check up in reality what happened to his projects. So once you do all this due diligence, I think it is worth buying in a redevelopment. But I will still feel a better ready position is a better if you can afford to buy. But otherwise, if it this kind of thing, because if you are a what you say rehab person, you are staying in a flat and you want a
Existing
new
member,
flat
yeah.
and there's a lot of leakages, we are desperate. Don't go for desperation. See whether that builder, and don't go for all the amenities, because there are a lot of yeses. अरे वो बिल्डर ने तो एसी फुकट दिया, वो बिल्डर ने तो पार्किंग फ्री दिया, स्विमिंग पूल बना दिया. No, you have to check whether you will get your flat back with an increase that he promises, with a good additional area, with a good amount of the entire compliances in the building in the requisite time. Because he promises you 18 months, 18 months में interior भी नहीं होता है. Very few builders must have done in 18 months. I'm not saying there are builders who have done, but don't go for 18 months. You should be ready with a rent for 3 years minimum, because redevelopment takes 3 to 5 years these days. And then for small thing, not a flat builder will sell his flat, like it happened in Tilak Nagar. They sold all the flats to the sell portion. The portion they gave a possession, and then there was no OC to them because builder did not pay development charges. Later took a stand that development charges will be paid by society because they are doing the redevelopment in their name. I was only the contractor. We got the award from the National Commission that builder made so much profits, and the development charges is a duty of builder to pay, not of the society. And then finally they have to pay. I can name these societies. There are certain